Okay, we're officially live. Hey,
Yay.
Johnna, how you doing?
Another big week in immigration.
Oh yeah, good times. All right. Well, Johnna and I have agreed on 7 things we're going to talk about, but we just got a comment on another thing that was kind of breaking news that we're adding an 8th thing. So we will have a bonus thing number 8 this week. Johnna, let's just start out with the thing that probably I've gotten the most people asking me about. This is the one that made the news, and lots of like family and friends and others are asking about it because it made national news. So this H-1B proposed fee sounds very familiar.
I was about to say, is anyone surprised?
Sounds a whole lot like an executive order about 1 year ago, 11 months ago that went into effect, that has been struck down by at least one court. It's still pending in a district court and awaiting a decision in a federal appeals court. So we know that this executive order mandating this $100,000 fee has lately not been doing very well in court.
Right.
What is this new proposed rule, and what's the difference between that and what happened last year?
Yeah, there are some distinguishing characteristics of the current proposed rule. We knew this was coming. You know, the old fee.
I didn't know it was coming.
Well, come on, Greg. We've talked about this.
I thought they were going to try and extend the executive order. Doing it as a proposed rule.
True.
Not how I thought this was going to play out. In fact, I've been having this public debate with Chuck Cook, who I was like, Chuck, they're going to let this thing die because it can't survive litigation, and it's and ultimately they didn't make very much money on it either. So I was surprised, although go ahead and tell what the differences are.
Well, I was going to say we knew the first executive order had an expiration date. So whether it was done through an extension or a new executive order, or to be fair, the mechanism of a proposed rule was a little bit of a surprise.
Okay.
The fee is effectively the same. You'll see some added dollar signs, maybe reflective of some inflation there, but there is a carve out in there, Greg. We have, as a practice area, been watching for approvals of national interest exemptions, which effectively did not exist in the last 11 months since the old executive order came into effect. This new proposed rule actually has a carve out for those organizations that are petitioning that are cap exempt. So this is a little bit interesting, and I think any nonprofits or government agencies that haven't been using that say affiliation agreement to become cap exempt, this is your time. So right. That's kind of a natural exemption.
This is not going to live.
True. Yeah,
it's not going to live because it's so. Just to give people sort of a little background on the H-1B. This $100,000 fee from last year. There were 3 lawsuits. The first was a win for the government in D.C. That was the first one to judge the district court judge. As a Beryl Howard, or anyway, she let the administration have a pass on it, and then it got appealed, and that was the U.S. Chamber of Commerce's case. The next suit that got filed was our case in San Francisco, and our case was argued in March, and we still don't have a decision from our judge. And I think he's not feeling a whole lot of pressure right now to make a decision, because there was another case that was filed in Boston by 17 states attorneys general, and it's called California v. whoever the DHS person is, at the time it was what was her name? I already forgot her name. I'm blocking out of my memory. Our past DHS secretary.
No.
the dog hater. And then the so a judge ruled in that, and it's called California. The California v. Trump administration person, but it was filed in Boston, so it's a little confusing sometimes when you see the name of the case to realize that it's a Boston case. But a judge ruled that it was unconstitutional because it says right there in black and white in the Constitution that Congress has the power of the purse, and they get to decide what new taxes are legal and what new taxes are not. The president cannot unilaterally impose a tax unless he's given that authority by Congress, and they were not able to point to anything in the executive order or in the statute, the Immigration Nationality Act, that gives the president authority to issue basically a tax. He can do a fee if you can show that it costs USCIS $100,000 to work on an H-1B case. I suppose they might have a shot, but they already have a fee for H-1B processing that is based on how much time it takes, and that's already in the law. So that wasn't going to work. So they lost. And if they try and bring this back in through another proposed rule, they haven't explained why doing it through a regulation is any different than doing it through an executive order from the perspective of the constitutionality of the whole endeavor. So I don't see how this survives if they go back to the same court.
And I don't think it survives either. I'm just thinking practically for those foreign nationals who need a petition. A cap exempt organization is your way around that.
So that is correct. I will say though, the other challenge is as soon as this rule is finalized, and you can't sue until there's a final rule, then you have to depend on a judge to essentially issue either a temporary restraining order or a preliminary injunction. Preliminary injunctions we know don't go very fast because we just are seeing them stretch out for months and months. So it's going to have to be a temporary restraining order, which is a very high standard, not so easy to get, and you're depending on a judge to act really quickly before a rule goes into effect. And I think we'll assume that it's going to probably go into effect 30 or 60 days after it is published. I don't think they can get away with doing it faster than that. So there is a possibility that a judge just won't get anything done in time. And you're right that if that happens, then you're going to have to comply with it for at least a period of time. So that's this proposed rule. I'm telling people not to have panic attacks about it. Probably a good idea to file your H-1B cases if you can, but it's not I'm personally not losing a lot of sleep worrying about whether this rule is ever going to become into effect again. But
before we move on, I think
I am a notorious optimist.
Well, assuming we have to work with the rule for a little period, I think another point of note in terms of being distinguished from the first executive order is that this applies to both consular case and in-country change of status, change of status. So in that way, we see some distinctions from the executive order of last year.
Okay. All right, let's move on to thing number 2. The 75 country ban. There was litigation there was some successful litigation. We have our own case, which is basically still in progress. But there's this other case, and we certainly we're about to let our judge know about the case of Clinic v. Rubio. So congratulations, first of all, to Clinic. That's Catholic Legal Immigration. What's Clinic? It's the Catholic Legal Services, but I forgot exactly what the acronym stands.
Not the full acronym either.
For Immigration and Naturalization. Anyway, Clinic versus Rubio. So we have a judge, Judge Vargas, striking down this policy a couple days ago. So tell us what happened.
Yeah, so as Greg mentioned, we actually have our own lawsuit on this issue. If you recall, shortly after the 39 country ban, the 75 country ban was announced. What's distinctive about the 75 country ban is that it is an immigrant visa ban, meaning it's a ban for those who are consular processing outside the United States and coming in. So yes, a win for any pro-immigrant group is a win for us all. So we're thrilled to have this decision and kind of require DOS to continue processing. But then
Right.
when you see those parentheses, there's a little asterisk there.
Right. But we see this like report come out of the Washington Post early this morning, and I think some other places have been repeating it, that there's another, there's another holdup globally that's happening on immigrant visa processing.
So this is
is
not
this
just
just basically completely ignoring Clinic v. Rubio's decision?
Yes, but this is not just specific to the 75 country ban. So
I get it, but it's like
besides hearing media
but
reports,
wasn't that 75 country ban based on like the same reason why they claim that they've stopped processing?
One would think. So
why are they stopping? What are they? What's their excuse?
Good question. The question is we don't know. The theory is that globally the consulates have shut down, meaning more countries than 75 countries have shut down for the Department of State to initiate training for officers to be able to implement their own version of the public charge rule that USCIS has recently.
So we have some good journalistic outfits that are reporting this, or at least one. I saw the Washington Post story. I don't know if others have confirmed it or not, but we haven't seen anything from the government yet, like admitting that they're doing this. So all we have is the reporting, and the Washington Post has a pretty good track record of not reporting for something unless they have a pretty good reason to believe it's true. Okay, so we have that, and it is employment, family, and employment based and family based. Is it? We got this question earlier today on our Impact live stream about whether it's being applied to DV cases, and we don't think so. But if anybody actually hears that, and that's a DV applicant that gets that as an excuse, I would be curious well, first of all, I'm curious about like what they're going to tell you if they're canceling appointments, or what's if anybody is in that situation, I'd be really interested in seeing like what the text is of the email that they're telling you, as far as how they're explaining it, which cases they're covering, what you do if there's any kind of emergency or anything like that. So we but as far as the public charge and issues and all that, we know that that's already a running theme, that even though we haven't heard if the state has implemented the USCIS public charge rule, we do know they have been pretty aggressively challenging applicants over public charge issues at consular interviews. So I think the advice we had earlier today was just proactively go with a lot of documentation on the public charge issue. For example, if you have a DV interview or anything that's coming up, just assume that that's going to be an issue, that's going to be a serious one that you're going to have to deal with, whether they get their training or not. I mean, I'm sure the training is going to be basically saying you should be denying more people for public charging, and here are things that you should ask for that no one's going to be able to deliver. But if you, I would probably be talking with counsel about arming yourself with lots of documentation to show you have family in the U.S. with money, that you have jobs lined up, that if you're coming based on employment, to show proof of the salary offers, and that the job itself is for sure happening, and any personal assets that you have. Just basically go armed like you were going to apply for a loan from the bank. That's why I always tell people to think about the public charge issue. Act like you were trying to go and get a mortgage. What would you need to prove to the bank to show that it's risk, you're worth the risk? So that's what's happening regarding the 75 country ban. Good news from the litigation front, bad news from the administration trying to thwart the orders of a judge once again. Okay. what is this? Another $100,000 fee proposal. So it's like, I think that, well, I'm sure it's because the president likes big round, likes these big round numbers. But Johnna, what are they doing to these poor students?
Yeah, so that's right. Like for those of you who need a reminder, OPT is the post degree form of employment authorization, meaning poor broke college students who are trying to get their first job in their career. So
Yeah,
it feels like an extortion to say this is the fee to remain in the United States. And
crazy.
nice round numbers. I mean, I my thought on that when I see that, and it mirrors the same fee from the executive order, is like somebody was drinking in a late night meeting and they were like, put another $100,000 fee to solve
All
this
right,
immigration problem.
Johnna,
Quotation.
will this become a thing?
Oh, I don't think so. No, I think that you think
It's
yes.
unconstitutional for the same reason the H-1B fee is unconstitutional. Congress has not authorized them to do this. They are the ones with the power to tax, unless they can show somewhere in the Immigration and Nationality Act that it specifically says the president can impose some fee that has no connection to what the actual cost is of providing the services. And Congress does a lot of times actually put things in that are specific fees for specific things, but they're usually quite specific at the level that they're at, and they might have an elevator for inflation or something like that, but they usually don't give the president the ability to just come up with some wildly massive fee, even when they do give the president some authority. So this is going to be thrown out. Yeah, I'm being recorded right now, so somebody can come back to me for the same reasons, because somebody is going to file a lawsuit it's very likely going to be in Boston, where they've already shown that they don't have a lot of tolerance for illegal taxes. Let me also just back up. This is not a liberal thing. The U.S. Supreme Court ruled in the last term in favor of Congress on tariffs, and they threw out the president's tariff scheme because they said Congress hadn't actually authorized him to just unilaterally issue tariffs, which are taxes. He had to actually get the approval of Congress in order to do what he did. It's the exact same thing here. In fact, the case in Boston from the 17 that was like the strongest argument they had, was just citing the Supreme Court argument from a couple months ago. So that is what is going to happen again. There's Administrative Procedure Act arguments that you can make about all kinds of ways left and right that they're violating the rulemaking rules, but this is going to be thrown out on constitutionality grounds. That is my prediction.
Agreed. I'm going to bring the practical perspective, which is, it took us all of 10 months to get any kind of positive decision from the H-1B fee rule. So for those who are approaching their end of season of a particular degree, it may be time to extend that until we have some resolution through.
That is true, but we also didn't have a decision on the issue already sitting at a court.
True.
So when this case gets filed, it's probably going to be related back to the same judge. Maybe not, but probably, that issued the fee decision, and the government will oppose relating it back to that case. But I think that there is a decent chance that it's going to go back in front of that judge. But even if it doesn't, it's precedent now that for that district court, and they're going to have to consider that issue. I just don't see that unless you get a judge with a very different political bent, which is not that easy to do in Boston, because I don't even know if Trump has any appointees in that court. They're going to look very seriously at the H-1B arguments, and I just don't see this surviving. So that's another one. Don't be panicking every day and have sleepless nights. I am predicting that this is not going to be the law for very long. Okay. Thing number 4, Johnna.
Ooh.
This caused a lot of chatter today when I broke this news on our Teams chat with our attorneys today, and I had skepticism which is why I put a question mark here. But I will tell
Yeah.
you, my source, because we were actually on 2 hours ago. Jesse Bless, our friend and fellow litigator who we sue the government with often. Jesse was at the Immigration Service office today, and he had a client that was supposed to be getting an EB-2 visa. Um, and the officer went on the computer and he said, it's saying there are no EB-2 numbers left. And then Jesse talked to another officer who said, yeah, that just happened. It happened in one of my matters too. Apparently, it happened, but at least Jesse is quite sure that is what the State Department is telling USCIS, that there are no numbers. Chuck Cook and I, when we initially heard this from Jesse, were the opinion that can't be true, because there should be way more numbers than there were at this time last year.
Because
We had a 75 country immigrant visa ban. We
and
had a 39 country adjustment of status pause. We had a slowing economy.
right.
We had there's like a million different reasons why there should be lots of, and Britt Simon Britt in our who is the DV guru, also loves crunching numbers. He was in our chat today, and he said he had already done a dashboard on EB2 usage, and said that 6 months into the fiscal year, they had only used about 4,900 out of the 40,000 or so that they should have, and they should actually have quite a bit more than that. Chuck thinks it's really more like 60,000 because of rollovers and other things. So this would mean that they would have basically had to increase the pace by about 1,000% in order to use up those numbers.
They could have done it, Greg.
Right.
Even optimist
So,
Greg
Mike,
doesn't believe that.
what is happening? So, and then Elisa Taub, who is our DOS guru in the on our chat, who's like, well, DOS, when this happens, announces it immediately on their website. I haven't looked since about 2 hours ago, but there was nothing on the website about it yet. Maybe somebody can look and find it and tell us in the comments that they found the link to that. So we don't know. We have this report from a reliable source, Jesse Bless, who is not prone to to just make up things like that. So I'm sure that he's pretty comfortable that that's what state is telling USCIS. Now, I pose the question of maybe there's something that they are not telling the USCIS officers, the line officers who are making decisions, and maybe saying there's no numbers available only because they made numbers unavailable temporarily, maybe while they're going through training, or maybe while they're doing some kind of new vetting or something like that. So they didn't, whether just because that's, normally when they don't give you a number, and that's never used for any of those purposes, maybe something's going on. So I would like to see what the official State Department position is on it. Look, it's possible. I'm not trying to say that it's not that it's impossible that this happened, but
it's not an impossibility. It's a very unlikely probability.
So
I have my own.
I will keep a question mark there until we know more. Okay, and it looks like a couple of people are commenting. Yeah, okay, we'll get to the Omnipot's questions in a little bit. Okay, all right, back to our list. Thing number 5. This was also something that was causing some chatter this week in our very busy. We have a very busy Teams channel for our lawyers. It's like if you're like basically doing work for an hour or two, you completely are behind. You have to like check this thing every hour in order to know what's going on. But there was a lot of chatter about the new public charge regime, driving practice changes. So this is not I guess it's not technically breaking news, but it is a thing. And I wanted to see what you can say, sort of like what were some of the takeaways from this internal discussion that we were having.
Well, I mean, I think every attorney right now is doing their own analysis for high risk cases for the new public charge analysis and trying to make a determination of if we need to file before September 18th. So I think the big takeaways are, especially for like parents. So if a US citizen child, adult child, is petitioning for, say, an elderly parent or someone who cannot work due to a disability or medical condition, those are people I'm like putting as a high priority that we need to be filing before the implementation of the new public charge rule. The the service is effectively doing this analysis to determine what do we think about your ability to work, your likelihood to find jobs, your employability. So, Greg, kind of like what you were talking about, coming prepared to get a bank loan, it's almost like putting together your professional resume to show these are my hard skills, my soft skills, here's my work history. So maybe I don't have a job today, but I'm very employable, especially if you approve my permanent residency and I have not employment authorization, but I'm authorized to work. So I think we have to think about cases almost in that context and documenting them accordingly. So there's still a lot of unknowns, and I say that having sat through trainings and all of our discussions of the last week. But I think we'll come to know more and more as weeks go by. But if your attorney is talking to you and kind of hurrying up the process, it's because there's kind of this urgency to file the cases that we can in advance of that change.
I mean, there was some discussion as well about, affidavits of support and joint sponsors, which is what we've done in the past with the traditional, and sort of a belief that those would not carry nearly. I mean, they're not as they're helpful, but they're not going to carry nearly as much weight as they did before. So that, I mean, what's your personal take on that? Or, I mean, would you? I mean, I think we're going to be sending people with those, but
we have to. So the concept of a public charge has existed in our immigration system for 100 years. But the way we have traditionally fulfilled that and met the requirement is through a sponsor and sometimes a co-sponsor. But to the extent we're now looking at all these other things, it does seem to be kind of an indication that just having a qualified sponsor or maybe co-sponsor too is not enough. And so I think there's a lot of fear in terms of private practitioners when we think about DOS doing training, because there's been no announcement on Department of State implementing this and how those cases that were just canceled without much notice. I have clients who are now outside the US waiting for their appointments that were scheduled this week and trying to know, oh, well, you are already outside the US. How are we going to best prepare you for this change when there's been no standard of what it is exactly we're proving? So just like Greg said on the loan, it's like we're going to be over documenting to make sure an officer can really see eligibility.
Yeah, I agree. Okay. The DS lawsuit. So DS is duration of status, and this is this is something that I think had just been filed last Wednesday when Marshall and I were on the air, and neither one of us had any time to really think much about it. But basically, we have this we have this lawsuit that I'm looking for my notes so I can tell you what the exact name of it is. Hang on. Where's the lawsuit? Oh, here we go. It is called President's Alliance on Higher Education and Immigration et al. Versus DHS. And it was filed in Massachusetts, in Boston, where all good lawsuits are filed. It's not the only place to file, but I like that jurisdiction, particularly for this issue, because I remember in the first Trump administration, the Harvard sued when they basically tried to keep out all the students with various bans that they had in place in the first Trump administration. Which, by the way, they tried to do this in the first Trump administration as well, this duration of status nonsense, and getting rid of that. And for moving it on to I-94s, but they did it by memo, and they lost because they did it by memo. Not that it was super well. I mean, not that doing it by regulation was any magic formula for them, but that was their takeaway. It was like, we'll just do it by regulation the next chance. So that's what they've done, and so you've got this. And NAFSA is also a part of this, and everybody who's a student knows NAFSA is that's all the foreign student advisors. It's a great organization. There is as well the UAW. Remember the UAW? That's one of our plaintiffs in our H-1B case.
Oh, that's right.
And a couple other unions. Love the unions. Anyway, they sued and basically said that this rule violates they violated the Administrative Procedures Act as far as how it was rolled out, and they had a lot of interesting arguments. It was they said it was an inadequate comment period. No surprise there. They didn't read any of the comments, and that's actually another complaint is that they failed to give meaningful consideration to the comments, and that's basically how it goes. Is that this rule was going to be final without any changes, no matter how many comments there were, and they were mostly negative here, and that it was arbitrary and capricious decision making. So, in other words, if a judge believes that this is just anti-immigration nonsense, and I don't know if they argued animus. That's my favorite APA argument as well, animus, because everything the administration does is with animus. So if you get a judge who is, really kind of like focuses on the motivations, he'll probably rule on animus. But anyway, the suit is filed. It is on a super fast track. You and I were talking about it beforehand, and we're supposed to be having I think the government's got till August 31st. There's an in-person hearing scheduled, I guess it's TRO, on September 3rd. Anyway, so it's going to be moving pretty quickly. I guess the rule goes into effect September 15th. So they're trying to get a decision before that happens. And there was a very significant development today, which is why I put it on the list, which is, remember all those state attorneys general that filed the lawsuit against the H-1B tax in Boston? Well, they got the band back together, and they filed what they call an amicus brief or an amicus brief. I never know how that's pronounced. I know. I feel like
I always say it wrong. I say amicus, but I think I hear amicus more commonly.
Right. It's an amicus/amicus brief, and in this case, essentially telling the judge, here are the senior law enforcement officials in 17 and several of the biggest states in the country who say this is not legal and that this shouldn't be happening. I think it came from the attorneys general, but I'm sure it was also making all the arguments about why it's just bad for states from economic reasons and all kinds of other things. I have not read it yet. We just heard about it like before this happened, but I wanted to mention it because I think people last week were asking about this case, and I wanted to say more about it than we did last week. Last week just said it got filed. Today we wanted to actually say a little bit more about it, which we have. So litigation works sometimes, a lot of the time, and hopefully in this time. Okay, last but not least, speaking of litigation, this is not last.
Speaking of litigation working.
I'm great. I'm gonna
well, that's right. Surprise the brain.
Okay, so Johnna, what happened in our DV case?
So yeah, bravo to the legal team of Impact because this was our case. So diversity visas were announced as being halted late last year. And so the lawsuit was targeted at saying you can't just announce a full stop to an entire immigration program. So yesterday we did have a win. The win is narrow. So it's not all cases get to win. It effectively is preserving the ability for some to process. For those who don't know about diversity visa, it's a very time sensitive process because you are selected and have to fully complete receiving your visa by the end of the fiscal year, which is the end of September.
There's no forgiveness for being late.
Yeah.
So here's the good news is the judge said our arguments were legally correct and that the government has to adjudicate them, they have to start the process of adjudication. He didn't act. We're not super thrilled with how the order was actually implemented in terms of forcing the government to actually finish up work on these cases.
Yeah.
We are endeavoring to try and get clarification from the court, from the government on how they are planning on doing this, and hopefully getting a judge to closely watch what's happening so that they don't just run out the clock and through largely ignoring the order and saying, "Hey, all right, we'll try. We'll start. We'll start looking into it." So that's that. So the good news is the judge agreed with us. The bad news is we still don't have a guarantee that these cases are going to happen on time. We have been telling folks first of all take matters into your own hands. Start contacting the consulate. Start contacting them every day. Remind them that you are the beneficiary of a court order, and hopefully you'll be enough of a nuisance that they will do their job. We already know some of our plaintiffs have said they contacted the court, the consulates today, and the consulates acted as if nothing happened, even though I think some of them were sending the court orders. So they will get the word. The State Department will, I think, deliver that because they're going to have to report to the judge anyway that it's happened. But that is it is a win. It's just not things are not that crystal clear how we're going to get all our people yet to the finish line.
Especially when you think back to our second item, which is about immigrant visas being paused by Department of State's own initiative. So
yeah, we think we don't think that DV is paused, but we also don't we don't have I haven't seen the definitive thing excluding them yet because we don't have any evidence that this has happened other than a news report. Okay, Johnna, the last item, the last thing. So we had somebody ask us this right at the beginning when we were looking at comments. Somebody's already asking, can you talk about this? And it is actually breaking news. So
yeah, I had not even realized this. Now, this actually relates to an announcement from August of last year, kind of putting us on notice that when an individual files an N-400, which is an application for naturalization, that the service has the discretion to conduct these neighborhood investigations. I have not personally had my own clients report this back, but I have heard of colleagues, including in the Memphis area, but also nationally, who have said, yeah, they really did before my clients' interviews show up to their neighborhood and just knock on doors of their neighbors. So it's not a memo, it's a policy alert today, or yesterday rather, is very, very similar, just affirming that in the agency's discretion, they can conduct these interviews. I am very curious what in the world prompts a neighborhood investigation. I am similarly super curious what they're really learning by neighborhood interviews in a modern world where we don't all necessarily interact regularly with our neighbors. I find this incredibly curious, and what in the world the service is actually doing with a very time demanding requirement of driving to someone, knocking on a door in hopes that someone is actually answering and responsive.
Yeah, I mean, I'm just looking at the memo that came out, and they do say that USCIS can waive the neighborhood investigation,
sure, which is what they've effectively been doing.
Right. But they give some more information on that, which I'm going to read this because I think it's helpful. provides aliens for naturalization. This is describing the policy. This is in the highlights. Provides aliens applying for naturalization may voluntarily provide testimonial or character reference letters, preferably from U.S. citizens who are not family members, who attest to the aliens' eligibility, character, loyalty to the United States, and attachment to the principles of the U.S. Constitution and other naturalization requirements, which is just kind of a natural thing that people say when in conversation. My friend Bob, he is exactly the type of person who will attest, who will be loyal to the United States and attached to the principles of the U.S. Constitution. That's what people say about their friends.
Now, I do think, coming back to the practical advice, I think there are ways of documenting this in hopes that you don't get a neighborhood investigation. So if you're not already preparing your application and filing like letters of support from, it can be neighbors, but yes, U.S. citizens who are not family members, religious leaders, employment.
You know which one I like?
Which one?
Principals of schools, where they can say, so and so is one of our students and his parents are super involved in PTA, and they are role models for other parents, and they're always volunteering at the school.
Absolutely.
Yeah, that's a good one. I mean, there's like lots of that. The churches are great as well. But yeah, take it seriously, because now that this is out, I think it's going to make it harder for USCIS officers to completely ignore this. And there are other, I think they're just going to, like, I think a lot of them are not really interested in going to these neighborhoods and knocking on doors.
No.
That is not something, I think, for a lot of them that they're going to be super happy about. So I think they would like to look at evidence that's provided the way I just described, but they're going to need to have documentation for the file. So take it seriously, give them what they need. And then hopefully, I think that, and hopefully they just act reasonably. I mean, you always have I think most USCIS officers are reasonable people. And I think they take their job really seriously, and they really do want people who have reached the finish line for naturalization to be treated fairly. So I will. I'm hopeful that we're not going to see abuse of this authority by USCIS officers. So, I don't think we've had any clients yet that we could like point to and say that this person was like really treated unfairly over this issue. But we're all taking it seriously. And that is all I have to say about thing number 8. Do you have anything else to add on that?
Nothing else.
All right, let's see if we had any comments that are. Sometimes people ask good thing. So, by the way, Orlando, thank you for asking that question, because we were not going to talk about that until I saw that question. So, thank you.
Yeah, Orlando is credited for our bonus content.
Oh yeah. So is this true that the 100,000 is on top of the 100,000? Wait, proposal said 103 would be on the 100,000.
So the 100,000 fee from the executive order from last year is expiring in September. So the executive order was valid for 1 year from the date of the announcement, meaning the new $103,000 fee is going to be in effect after the $100,000 fee. Now, you're right. Like, there could be a separate executive order, but kind of like Greg said, it seems obvious they've lost on that. So the proposed rule was their attempt at a workaround. We don't think enough to survive the scrutiny of a lawsuit, but no, it won't be $203,000 for an H-1B.
All right. Well, and thanks as well for the reminder. I'm glad he's one of our regulars on the live stream. He went earlier today and was mentioning that Jesse talked about Ukrainian adjustment, that he had 30 Ukrainian adjustment status cases for lottery winners already. So, but he is I think they may have been through litigation
case. Exactly. So Jesse's primary function is federal litigation, meaning, yes, he likely represented them in their adjustment, but likely also had an accompanying smaller pointed diversity visa case for the Ukrainians.
Yeah. Okay. Well, we don't have any more questions, and we've covered all our things. So, Johnna, thank you for being here this evening.
Always.
And I always say I hope that next week we'll have more positive stories, because it's always bad news. Although we did have our
Oh,
DD.
you are ever the optimist.
We had the DS lawsuit. That was positive. We
True.
had
This
our
was
DV
kind of a
win.
positive week. We had EB2 exhaustion and kind of
we
a
had the 75 country
but
win.
yeah, I think this was an overall hopeful week.
Right. We had some good ones. All right. So hopefully more next week. And thank you guys for watching, and we'll see you the next time. Bye-bye.